Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back on Cargill v. Garland, the bump stock case that's coming before the United States Supreme Court later this session. Now, this is a really important case. It really doesn't have a lot to do with bump stocks. It has everything to do with how the ATF conducts business, their playbook. And when you take a look at what could happen in Cargill v. Garland, as well as the Loper Bright Enterprises v. Raimondo case, yeah, this could be a very bad year for the ATF. Now, today was Amicus Day. This is the day that everybody's got to get their Amicus Briefs on. And I had a chance to geek out on a bunch of them, and all of them are fantastic. We're going to give kudos to everyone that filed one here in a second, but there's one. There's one that really stood out. It didn't stand out so much for the arguments, although the arguments are good and I'm going to share them with you, but it had an awful lot to do with who one of the named parties was on the amicus brief. We're going to give some kudos today to our good friends at Palmetto State Armory. They have decided to throw their hat in the ring, and I think that deserves a little bit of kudos. So today, let's get you all educated and let's talk about the gun company willing to put their mouth where your rights are. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by the conservative ladies of Washington, who along with Washington Gun Law will be hosting a live event this Saturday, February 3rd at 6 p.m. We will be streaming live to the YouTubeverse from Security Gun Club. Please stop on by and join us as a live audience. We got a bunch of really cool guests lined up, and then when we're done at 7 o'clock, we're all going to head over to Triple Horn Brewery. We're going to have some refreshments. We're going to geek out for another hour. So join us. Saturday, February 3rd, 6 o'clock live at Security Gun Club, 7 o'clock live at Triple Horn Brewery. Okay, so what we are talking about is the flurry of amicus briefs that came in on Cargill v. Garland. Now, for those of you who don't understand what an amicus curiae, everyone's got different ways of pronouncing it, but if you don't understand what it is basically that is a friend of the court. That is not the named plaintiff. It is not the named defendant. It is somebody supporting one of those two sides who offers additional memorandum of authorities to the court. Now, if the parties coordinate their efforts really nice, you can take very complicated issues and kind of spread out your page length across all your amicus parties and get everything thoroughly covered. Now, I wanted to point out that there were a lot of folks who actually filed amicus briefs in support of Mr. Cargill. I have a list here. I want to read them to you so you can understand everyone who threw in on this. Gun Owners of America, Gun Owners Foundation, Gun Owners of California, Heller Foundation, Tennessee Firearms Association, Tennessee Firearms Foundation, Virginia Citizens Defense League, Grassroots North Carolina, Rights Watch International, America's Future, U.S. Constitutional Rights Legal Defense Fund, and Conservative Legal Defense and Educational Fund. That was all on just one amicus brief. Here's who else. The NRA, the National Association of Gun Rights and Rare Breed Triggers. Kudos to you, Rare Breed Triggers. The National Shooting Sports Foundation, Firearms Policy Coalition, Firearms Policy Coalition Action Foundation, the Manhattan Institute, Pacific Legal Foundation, the Buckeye Institute, Second Amendment Law Center, FFLs of Illinois. Kudos to all of you out in Illinois. I'm sure you're having a wonderful year. The California Rifle and Pistol Association, an organization we've talked about here many times, and the organization Guns Save Life, which is true, by the way. But what I want to talk to you about today is the Memorandum of Authorities that was filed by the Firearms Regulatory and Accountability Coalition, FRAC. You've actually seen them once before on a pistol brace case up in North Dakota, and our good friends at Palmetto State Armory. Now, I went back and I kind of decided, hey, I'll go back and I'll look at Bruin, I'll look at McDonald, I'll look at Rahimi, I'll take a look at some of these cases that have come before the United States Supreme Court to figure out how many times have we actually had a firearms manufacturer throw in on a case via amicus. You know, do we ever see any of the large firearms manufacturers actually throw in on a case? And I could not find an instance of that until now. So, whether this is a case of first impression or not, I think everybody in the Second Amendment community needs to be aware that Palmetto State Armory has actually put their money where your rights are because they have thrown in as an amicus. Now, I've had an opportunity to go through the amicus brief, and it's actually really well drafted, and I love what they've done here because I love taking the logic of an opposing side and absolutely using it against them. Translation, you love it when the opposing sides hangs themselves with their own rope. And that's exactly what FRAC and Palmetto State is arguing in this amicus brief. Now, as I also mentioned, Rare Breed Triggers, along with the National Association for Gun Rights, did file an amicus brief. Now, I think that Rare Breed Triggers did themselves real solid here, but let's also remember that Rare Breed Triggers obviously has a little something invested in the outcome of this case, because the technology that's at issue here with bump stocks is going to translate incredibly well to what's going on with the force reset and wide open triggers. As Palmetto State pointed out in their memorandum, neither Palmetto State Armory, FRAC, nor FRAC's members make or sell bump stocks or firearms equipped with bump stocks. However, they are opposed to firearms regulatory agencies altering their interpretations of criminal statutes through regulatory actions that outlaw conduct the agencies have long recognized as legal. Such actions threaten to turn millions of law-abiding Americans into felons overnight, as this case illustrates, and they unnecessarily disrupt the settled expectations of responsible industry players. The Constitution establishes that only Congress can make an act a crime. Palmetto State Armory, FRAC, and FRAC's members thus oppose efforts by ATF and other regulatory agencies to define new crimes through regulatory fiat. Now, here is the argument in a nutshell, and it's a really, really good argument, because if we assume an arguendo, as the ATF claims, that the definition of machine gun is somehow another vague and therefore requires further definitions, which the ATF can then do a rulemaking order where they can basically completely reverse course on something that they already said was legal, translation turning a bunch of lawful, responsible individuals into felons overnight, then the rule of lenity would apply to this, not any kind of deference to the ATF. That's right. The ATF is arguing here that under the Chevron doctrine, the Chevron deference, that they should be entitled to interpret their own statutes, that they are essentially the fox which gets to guard the henhouse. The problem is that there is a litany of case law that says when it comes to criminal statutes, you know, the types of statutes that actually put people in prison, the types of statutes that actually turn people's lives upside down, we do not get into a Chevron deference. Instead, we apply the rule of lenity. And this is exactly the point that the Palmetto State Armory and FRAC is making in their pleadings here, is that the rule to apply here is the rule of lenity, which says, hey, if a statute is subject to two reasonable interpretations, then the interpretation that the court must adopt has to be that of the defendant, or the least restrictive interpretation of that statute. As the amicus party points out, this is not this court's approach to criminal law. When the court interprets the National Firearms Act and the Gun Control Act, it applies the rule of lenity to resolve ambiguity against the government. And the court does not defer to the contrary view of the Bureau of Alcohol, Tobacco, Firearms, and Explosive because the government's reading of a criminal statute is not entitled to any deference. Accordingly, the government is mistaken to defend the bump stock rule as if it were acting within an area of policy-making discretion. If the application of the federal firearm statutes to bump stocks is ambiguous, then the result is not freedom for the government to criminalize, but rather lenity for those whose conduct the government would criminalize. The en banc circuit recognized this when it denied Chevron deference and applied lenity to invalidate the regulation at issue here. This court should affirm. But in addition to the obvious problems we have here and the need to apply the rule of lenity, what the amicus parties point out here, which is also dead on, is that, listen, if we allow this interpretation of statutes by the very agency that is tasked with enforcing it, that is, we allow an executive branch to do a judicial function, well, now we're in violation of the separation of powers, which was the exact arguments that were proffered in Loper Bright Enterprises v. Raimondo, which is the entire concept of the Chevron deference actually violates the separation of powers, as the amicus party put here. As these conflicting decisions make clear, a key question in resolving this case is whether an ambiguity in a criminal statute should be construed to favor the citizens or the government. The separation of powers resolves that question in favor of the citizens. The framers believe that separate and distinct exercise of the different powers of government is essential to preservation of liberty. And they do an excellent job of going through a litany of cases, and there is, in fact, a litany of cases that hold that the Chevron deference has no place when trying to interpret criminal statutes. Now, to kind of wrap up their argument with a big old bow on top, this is exactly where the amicus party comes from. In this case, the government contends it is free to reverse its long-standing interpretation of a machine gun, but it does not contest that if the statute is genuinely ambiguous, the government receives no deference and lenity applies. The government may not resolve ambiguity through the invocation of presumptive intent to facilitate NFA prosecutions. Given these viable competing interpretations, it would be difficult indeed to contend that the statute is unambiguous with regard to the point at issue here. And finally, they point out, ATF's rules interpreting federal firearms statutes are valid only if they correctly articulate the unambiguous meaning of the statutes. Because the bump sock rule does not, lenity requires that it be set aside. So again, kudos once again to the good folks over at Palmetto State Armory. I love to see a gun manufacturer actually jumping down into the trenches and getting their knuckles bloodied with the rest of us. We're gonna go ahead and link up their memorandum. We'll also link up the Supreme Court docket, so if you want to geek out on any of the other really well-drafted amicus briefs, you may do so. Obviously, we're going to keep you really closely posted on this case. This case has huge, and I do mean huge, implications. Now, in the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. Now, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.